Good afternoon. This is Terry Welch, one of the partners at Secrest Wardle, broadcasting from our offices in Troy, Michigan, here today to talk about understanding indemnification claims. I did this webinar on this topic several years ago, and I was really surprised when the firm told me that I had 3 or 4 times the number of claims people who watched my webinar on indemnification than all the other Secrest Wardle attorneys had watched theirs on other topics. And honestly, my first reaction was, oh shit, I'm going to have to do this indemnity seminar until I retire. I mean, let's face it, it's a pretty dry and boring topic that just doesn't carry the stories and the excitement that we sometimes get when we talk about most of our claims. However, my second reaction to getting the biggest turnout sank in when I wondered, why? Why me? And I realized that this is an area of the law that can rock your claim upside down if you don't get it right. It generally only applies to the bigger and more complicated high-exposure claims to begin with. It can greatly affect how you reserve your files and how good your reserves are. And it's an area that all of us need to know if we ever have to defend any premises or construction or building claims, even fire claims. And understanding indemnification is something that you all need to know to both preserve and advance your careers and to pass audit when the second guessers come around after the files close and start asking questions. So my job today is to help you do your job and to help you get it right and to give some practical advice on the everyday handling of these types of claims and to share some ideas on how to read and understand indemnification clauses themselves, which really isn't that hard. So I want to kind of mentor you as to you also need to reshape and kind of reconfigure your claims brains when you get confronted with these indemnity issues for reasons that I'll talk about in a minute. So here we go. Number 1, first you need to determine early on in any case arising out of written contracts if anyone owes anyone else indemnification. To start this, you need to gather up all of the contracts, whether it's a lease or a construction contract or even just a purchase order, to see if there is any type of potential indemnification issues hanging over your claim like a black cloud. And remember that indemnity is a two-way street. It can be both a shield or a sword, depending on whether you're insured and you ends up picking up the tab due to indemnification, or if you get your tab picked up by another party. So job 1 at the onset is to determine early what contracts there are and to review them so that you can properly set your reserves and take the best defense planning strategy that you can depending upon your indemnification language. Number 2, job 2, or the second thing you have to do, which is the hardest part here, is to forget everything you've learned about fault in evaluating indemnity claims and to just focus on the words and wording of the indemnification clauses, because, with one exception that I'll talk about in a minute, the wording of the indemnification clauses and the contract clauses is the only real thing that counts or matters here. And with one exception, fault does not count in indemnity claims. Only the words and the phrases of the indemnity clause count. And that's hard to do because you and I live in a fault world where almost all of our cases are decided on who is at fault, and all we really do is talk about fault, fault, fault. So look at this picture. The guy in the dump truck was killed, resulting in a big wrongful death case when he drove the dump truck into a structure that was lower than the top of the truck, which also caused hundreds of thousands of dollars in related property claims. So let's assume you're insured as the contractor whose structure was damaged. And you think, without reviewing the indemnity issues, that A, it was the plaintiff's fault, B, it was open and obvious as it gets, C, your people did nothing wrong, D, I'm setting my reserves low as a result, and lastly, I'm not paying jack on this case because it's not worth anything based on fault. But that's how we've been trained to think, right? Well, with one exception, you have to forget about fault and delete from your claims brain hard drive all of that fault philosophy that's embedded there, and focus on the indemnification language, because guess what? You're about to pick up $1 million tab because your insured agreed to indemnify the contractor whose negligent and dead driver drove the dump truck into the open and obvious structure. So my goal is to help you avoid such bad claim surprises. Secondly, and this is also kind of related to fault, but you have to understand something. And this took me a long time to accept as a younger lawyer. First, a party can contract away all of its liability, even if that party is at fault, if the language is right. Again, a party can contract away all of its liability, even if the party is at fault, as long as the contract indemnity language supports such a position. Or put it the other way, a party can assume another party's liability, even if the other party is at fault, as long as the language is right. And a party who is not at fault and who did absolutely nothing wrong might owe indemnification to the party at fault whose people caused the whole damn accident. If the language is correct, is all that counts. So again, it's all about the language of the indemnification clause. And that's just the way the law is, and that's just the way it is, and you're just going to have to accept that. Because indemnity is no time to talk about things like justice, fairness, equity, right or wrong, or things that generally shouldn't be discussed in lawsuits to begin with. It's all about the indemnification clause and the contract language, period. So let's go to that and talk about how to read and understand indemnification clauses so that you get it right early on and so that you don't get burned because of having to indemnify someone else's insured for their own fault late in the game. Now, let's face it, all of you and all of us, all claims reps and all defense counsel, have gotten pretty good at reading and understanding insurance policies to determine coverage issues. And if you can read and understand an insurance policy, you can absolutely read, understand, and properly evaluate an indemnification clause. If you read an insurance policy and understand coverage from that, you can take that same skill set that you use all the time and read and understand indemnification language so as to determine who might owe whom indemnification. It's really no different, and it's really that simple. One word at a time, one phrase at a time, just like you read a policy endorsement for coverage. So let's start at the very beginning and discuss who the indemnitor is and who the indemnity, that's with two E's, is, as in the indemnitor agrees to indemnify the indemnity with two E's from and against any and all liability, blah, blah, blah. So is your insured the indemnitor or the indemnity? In simple terms, the indemnitor picks up the tab and indemnifies the other. And the indemnity is the person who gets protected, even if they're at fault. And admittedly, this is a little confusing because the indemnity with two E's is really the screw or, and the indemnitor is the screw E. But here I am, now I'm letting fault and my claims fault philosophy cloud my indemnification judgments just after telling you guys to ignore that. But once you have your parties straight in terms of the indemnity clause, then you have to read the clause in terms of what it covers, how encompassing it is, how it speaks to causation, and whether it speaks to covering the indemnity, again that's with two E's, from their own negligence. And it's pretty simple if you read the clause like you would an endorsement in a policy. And just like they say in the cases involving coverage and insurance policies, you have to remember that every word counts and every phrase must be given its ordinary meaning so that the intentions of the parties can come out of those words and clearly state what the parties intend with regard to indemnification. But the law is clear. A party can be indemnified and protected from its own negligence so long as the indemnification clause is clear and unequivocal and not ambiguous, just like they construe insurance policies in the law. Now let me give you some examples which also sort of track with the history of the indemnity case law in the state of Michigan. Let's start with the phrase, quote, from any cause whatsoever, close quote, as in, Party A will indemnify Party B from any and all accidents or losses arising, quote, from any cause whatsoever, close quote. About 30 years ago, our appellate courts decided a case called Klann, K-L-A-N-N, that held that the words, quote, from any cause whatsoever, close quote, was clear enough to include the negligence of the party seeking the indemnification. So in Klann, Party B got indemnified for its own negligence because the clause used the magic words, quote, from any cause whatsoever, close quote. Now, as time went on, our clauses, the indemnification clauses, got more sophisticated and more wordy. For instance, they would, in a post-Klann world, would say, Party A will indemnify Party B from any and all accidents or losses from any cause whatsoever, but then added the words, including accidents or losses partially caused by the negligence of Party A. Now, the courts held that that's even better because that elaborated on the quote from any cause whatsoever, close quote type language and expressly addressed the negligence of Party A and expressly address the intentions of the parties that Party A would get indemnified even if they were found to be partially negligent or at fault. Again, clear language that expressed the intention that Party A was to get indemnified even if Party A was at fault. And again, every word and phrase counts and must be given its ordinary, plain, everyday meaning. Now, honestly, there hasn't been any appellate case law on contractual indemnification for years until a couple of months ago on April 15th when our Court of Appeals issued an opinion on contractual indemnification in a case called Miller-Davis v. Ahrens, A-H-R-E-N-S Construction. And what that case tells us is how important every word, every single word in an indemnification clause is. Now, in that case, the clause read, from any and all is the key word here, from any and all accidents arising from any case whatsoever, I misspoke. Let me repeat. Any and all accidents arising from any cause whatsoever. And the focus in that case, believe it or not, was on the single word, quote, all, close quote, as in any and, quote, all, close quote, accidents. And after several insurance companies had expended tens of thousands of dollars on defense costs, and after each of the parties wrote 50-page briefs, our Court of Appeals, in its infinite wisdom, literally ruled that all means all. and that, quote, all, close quote, evidenced an intent to protect the indemnity from its own negligence. Now, this is the part that puzzles me. One would think that as the case law has evolved, that everyone would use the same indemnification clauses that have been tested in court, but no, someone has to tweak them. It's kind of like underwriters changing policies to say something that is yet untested, resulting in oftentimes unnecessary appeals or unfair settlements. You know, there are dozens of examples of clauses used to date where a party has been upheld in the law as getting indemnification even though at fault, but time really doesn't permit us today to go over every single one of those different variations of indemnification clauses. So the lesson here in more general terms is to read and reread the indemnity clauses to determine if they express an intention to, number one, apply to your loss, number two, protect the party getting indemnified for their own negligence. And if that language is clear and is not ambiguous, your insured will either get indemnity or you will pick up the other party's tab. So make these determinations early before you get burned. Now this brings us to the issue of the tender of defense and why it's important to do this early on. This is a secondary issue, but it is a big part of indemnification claims as it relates to costs and attorney fees. First of all, you have to look at the indemnification clause to see if it used the word defend, as in, Party A will indemnify you, hold you harmless, and, quote, defend you, close quote, against such claims. Now, you can tender the defense without the word, quote, defend, close quote, in the contract, comma, but if the clause does say, quote, defend, close quote, then your tender of defense position is strengthened. Secondly, you need to look into what the insurance provisions of the contract state, and they are often part of the indemnification section or adjacent to it in a contract, and you need to look into those issues because that too can relate to a successful tender of defense strategy. If the contract says that the other party will name your insured as an additional named insured on their policy, then your tender of defense position is strengthened and is, for all practical purposes, if you've got a really solid indemnity clause, comma, it's golden. Sorry, I didn't mean to say comma. I live in a dictation world here. However, if your insured is named as a certificate holder on the other policy, then that really won't help you because a certificate holder is not an additional named insured in the eyes of the law, but is simply a party that's entitled to notice if that insurance policy gets canceled. However, remember this, you can tender the defense even if the clause does not say, quote, defend, close quote, and even where your insured is not named as an additional named insured on the other policy. It's just better if you have this additional language in your favor. Again, it's all about the language. You also need to read the contract clause. Now I'm getting back to the indemnification clause now. You also need to read the contract clause in terms of whether it says things like attorney fees or cost of defense. As in, Party A will indemnify and defend Party B from and against any and all losses from any cause whatsoever, quote, including costs or attorney fees, close quote, period. And that's better because, once again, it more clearly expresses an intention that not only will you be indemnified, but that you will also have to but that the other party will also have to reimburse you for court costs and attorney fees if it turns out that someone improperly rejected a tender of defense letter and then a subsequent cross-claim. Because obviously, if they don't pick up your defense, you have to tell your counsel to file their cross-claim. So that's why you have to do this early. And if they don't agree with you, you have to file the cross-claim early, and it's to get the clock running against the other side. Yeah, you got lots of time before trial and so on, but as soon as you tender that defense, the law says that if you're right and they're wrong, the clock starts running on the attorney fees and the costs from the moment you tender that defense. So it's important, just like reviewing the indemnification clauses in general, that you get your tender of defense planning strategy right from the get-go, and that you get it going as soon as possible so that you can start the clock running on the other side. Now, I mentioned earlier that there was only really one area of the law where fault is an important matter, and this relates to the statute that you now see before you, which is MCLS 691.991. And let's go over that statute, and before we go over it in much detail, just let me kind of paraphrase it. Basically what it says is that the statute says that in a contract involving the design, construction, repair, or maintenance of a building, which it says includes sidewalks and common areas, that Party A cannot get indemnification for Party B if Party A is solely at fault, is found to be solely at fault. And that's no matter what the indemnification wording says. In other words, even if they have all that good language we talked about there before, if it's a construction contract that relates to a building, then the issue is whether the person that wants indemnification can get indemnification for their sole negligence. And what you see in the bottom line of that statute that we highlighted in yellow is the court says that if that party is solely negligent, that the indemnification clause is against public policy and is void and is unenforceable. So what did we see happen in the evolution of indemnification clauses as a result of that statute coming into being? This is what happened. The clause is now read, Party A will indemnify and hold harmless and defend Party B from accidents of any cause whatsoever, including if caused partially by the fault of Party A, and here's the new language, provided that Party A is not found to be solely negligent in causing the loss. So if you have an indemnification claim where 691.991 is applicable, you might tender the defense and take the position that the other party is not solely at fault. Or you might reject a tender by claiming that the party who wants indemnity is solely at fault. But again, you've got to get this right early on, or you could end up picking up a big tab and 2 sets of attorney billings, and we know we all want to avoid that. But here's the hook, and here's the problem in my view with that statute. You got to keep in mind that in terms of the issue of sole negligence on the part of the party that wants indemnification, that the law says that you also have to count the comparative negligence of the plaintiff too in terms of the 100% at fault issue or the sole negligence issue. And we all know, without being facetious or sarcastic, that all plaintiffs are guilty of comparative negligence to some degree or another, if not, more than 50%. So if we go back to that funny picture of the wrongful death claim of the man who drove that giant dump truck into the structure I showed you earlier, if the jury assessed that plaintiff with just 1% comparative negligence, and the jury assessed Party A, the one that wants the indemnity, with 99% comparative negligence, then Party A would still get indemnification even though they were 99% at fault, because under 991.991, they were not deemed to be solely at fault or 100% at fault. And as a practical matter, and I've been doing these cases for a long time, you rarely ever see a case where Party A or the person that wants the indemnification is assessed with 100% and ends up getting no indemnity. One of the reasons you rarely see that is that these are big dice cases generally, and people don't want to try the cases on that issue for that reason, so they tend to get settled. But when they do get settled, they tend to get settled on the basis of an apportionment of fault and equity, which is admittedly contrary to what I told you in the beginning. So if you're assessing an indemnification clause under this statute, you have to assess the apportionment of liability as early on in discovery as you can, which is generally after the completion of the liability deposition phases. So be on the lookout for 691.991 issues and assess them on the basis of fault like you do every day in handling your other claims. We hope that this webinar has been instructive to you and that it will help you do your job more properly when confronted with contractual indemnity claims. As always, if you bump into one or you bump into a weird one and you need to talk to somebody, give us a call. Please call me. Please email me. We really believe that that's part of our job at Secrest Wardle to assist our claims team. Not only do we see it as part of our job, but a lot of times, we don't claim we know everything. We don't claim you know everything. A lot of times when we get these new weird things together, we talk it through and we both learn from each other so that we can use that information on future claims. And we're kind of in this mess together, and that's how we keep abreast and learn from each other. So please, if you have any questions about this at any time, even if it's a case in which we're not retained, please call us or email us. We'll try to tell you our thoughts and give you the best advice. So in the interim, we thank you for entrusting us with your work, and we hope that this has been helpful to you. And this is Terry Welch from Secrest Wardle signing off. Thank you.